Hello and welcome, everybody. My name is Mariana Campero, and I am the Executive Director of the Mexican Council on Foreign Relations, COMEXI. It is a real honor to host a webinar with one of the world's leading constitutional scholars and one of Mexico's leading and NAFTA experts. The questions this webinar will try to answer are two. If the President of the United States has the power on its own to terminate NAFTA, or if he requires congressional approval, and what could happen if President Trump actually triggers the exit clause. In the first place, I would like to welcome Professor JoelP.Trachtman, who is a professor in international law at Fletcher School of Law and Diplomacy. He is recognized worldwide as a leading authority on international law. He has published 6 academic books and over 80 scholarly articles. He has lectured in universities around the world. Professor, thank you very much for being here with us. And sitting next to me is Dr. Luz María de la Mora. She's an expert in foreign trade relations and policy. She has represented the Mexican government in various trade negotiations, including the NAFTA negotiations. She has been NAFTA chapter 19 panelist for many times. And before I pass the floor, I will briefly explain today's dynamics. Initially, Professor Trachtman will speak for about 15 minutes, followed by Dr. Luz María de la Mora. We will then open the floor to the audience for a Q&A session. I will ask all of you with us today to send us your questions via chat. There is a little icon on the upper right hand of your screen where you can send us the questions. Again, thank you and welcome, Professor Trachtman. Thank you very much. Luzma, thank you.
Thank you, Mariana.
Thank you very much, Mariana. It's an honor and a great pleasure to participate in this event, especially with Senora de la Mora and COMEXI and the Fletcher Club. Thank you very much. Before I begin to discuss the constitutional and statutory issues in domestic United States law, I want to say a bit about the context in terms of what Stephen Bannon, the former advisor to President Trump, called economic nationalism, which I might call instead populist mercantilism. This is an erroneous focus on trade deficits, which most economists would say are not important and are not affected by trade deals, and especially bilateral deficits, which are affected by so many other things besides trade policy. The Trump administration also seems to overlook gains from trade in terms of export jobs, intermediate goods, and most importantly, opportunities for consumption. Also, there seems to be a willingness to ignore the importance of the supply chains, the complex manufacturing relationships that have been created by NAFTA over the past 25 years that have changed the nature of trade and have made North America a much more productive entity as a group than it otherwise would have been. Also, the Trump administration, I believe, has exaggerated greatly the effect of trade on jobs, and especially the effect of NAFTA on jobs in the United States. And finally, the Trump administration seems to have disdained cooperation and ignored the importance of reciprocity, and especially, as I said, the importance of export opportunities. So a kind of exceptionalism, a kind of unattractive America first policy. Of course, all countries need to take care of their own concerns, but this failure to recognize reciprocity, I think, is problematic. So the question is about constitutional constraints. In a liberal society, the leader is not the country. Remember, Louis XIV said, "L'État, c'est moi," the state is me. That is not the way liberal societies operate. And we see an unfortunate failure of President Trump to express concern or offer aid in connection with Mexico's earthquake. And I want to say at the outset that that doesn't indicate the position of the American people. Mm-hmm. But I think it's important to say, and this is to use another Stephen Bannon term, that there is a deep state, there is a broader state that countervails the power of the president and constrains that power. And that deep state, first of all, includes experts like the excellent bureaucrats we have at the United States Trade Representative's Office. I know Senora de la Mora has worked with many of those people. Our media and our academics who can express views. And then, and this is what I'll focus on, we have the rule of law. We have checks and balances, constitutional constraints, statutory constraints, and of course, international law constraints. So the international law in this area is relatively simple. NAFTA in section 2205 specifies that the parties can withdraw after giving 6 months notice. It doesn't exactly say what the mechanics are after the giving of that notice, and we can discuss that in question and answer. So our question is really one of internal United States law. Within the United States, who decides on the termination, on the question of whether to give that notice of termination? So as I've mentioned, there are constitutional issues, there are statutory issues, and there's the question of who can sue, what kinds of lawsuits might be available to enforce the constitutional and statutory law in this area. So let me begin with the constitutional structure. And it's very important to say that under the Commerce Clause of our Constitution, commerce is an exclusive congressional power. And an important 1994 case, Barclays Bank versus California, expressed that view that the president has no power to regulate commerce. And indeed, as you know, when the United States enters into trade treaties, they're entered into as congressional executive agreements pursuant to a statute of the United States. And in the case of NAFTA, it's the North American Free Trade Agreement Authorization Act. So the treaty is signed by the president. The president is our organ of execution in international relations, but he's not the decider in commerce. That's the job of commerce, of the Congress, to vote a statute about the regulation of commerce. And indeed, in connection with the current renegotiations, the United States Trade Representative sent a notice to Congress saying that they wanted to begin the amendment process for NAFTA, which would be a new statutory authorization under the fast track or trade promotion authority. Constitution, important executive power. The executive power of the United States is vested in the president under the Constitution. But in this context, that's a power to negotiate and a power to communicate, but not a power to regulate, a power to determine the rules that the United States accepts in this area. So I'll explore that more in a moment, but before I get that constitutional question, I want to say that if Congress were to authorize the president to operate Section 2205 of NAFTA, and to withdraw the United States from NAFTA, there would be no question under the United States constitutional structure that the president would then have the power to do that. So under some uncertainty about the constitutional situation, the statute would be determinative, so the president can act with congressional authorization. It's also clear in our constitutional structure that the president cannot unilaterally terminate statutes. So Congress has the right to repeal statutes. So the NAFTA Implementation Act cannot be repealed
without congressional action. So that's an important restriction, a certain restriction on presidential authority. So under the Trade Act of 1974, Section 125, the president may at any time terminate any proclamation under the act. So the president can terminate proclamations, but that statute clearly distinguishes between proclamations and treaties, and clearly does not give the president power to terminate treaties, while it gives him the power to terminate proclamations, which are proclamations of tariffs, in order to implement the treaty that the United States has entered into. So Congress has never conceded to the executive, through a statute, authority to withdraw from treaties like NAFTA. Then under the NAFTA Implementation Act, which was, as I said, the statute by which the United States accepted the North American Free Trade Agreement, it specifies that the United States federal government can bring lawsuits under NAFTA, and so NAFTA has become a part of the internal United States legal system. And so it raises the question, could the president really repeal this part of our internal legal system by terminating the agreement? And then Section 107 of NAFTA specified that the amended Canada-US Free Trade Agreement. Remember, NAFTA had as its predecessor a free trade agreement between Canada and the United States. It states that when the Canada-US Free Trade Agreement is terminated, the statute would be terminated, the statute authorizing that. And so I point this out because it shows that Congress was aware of the concern that a statute might survive termination of the agreement, and it did not address that question in the NAFTA Implementation Act. The last thing I want to say about the NAFTA Implementation Act, and it's separate from my main topic, is that under Section 201B, the President is authorized to proclaim additional duties, quote, as the President determines are necessary or appropriate to maintain the general level of reciprocity. And that could be a dangerous thing in terms of a United States violation of NAFTA that might cause retaliation and then termination. So to conclude on statutory authorization, in the NAFTA Implementation Act, Congress delegated proclamation authority regarding tariffs upon termination, but not the authority to terminate the treaty. And indeed, if we look at the WTO statutory authority, in that statute, Congress delegated much decision-making authority to the President, but also specifically avoided delegating termination authority to the President. So Congress has been very careful to specifically avoid delegating termination authority to the President. Therefore, it's clear that there is no statutory authority to terminate NAFTA that is allocated to the President. So then we get to the question, does the President have independent executive authority to terminate the NAFTA agreement? And here, the idea is that because the President has executive power, that executive power might include the power to terminate a treaty. And indeed, in an early 1936 case, United States versus Curtis Wright, that court said that the President is the, quote, sole organ for diplomacy. And so that has been understood by United States officials since 1936 as giving the President broad, in some ways unspecified authority in international relations. But in a 2015 case called Zivotofsky versus Kerry, the U.S. Supreme Court said, no, that's not true. There isn't broad, unspecified authority in the President. And so that raises a question about the extent to which the President has in his presidential executive authority the power to terminate treaties. The judges and professors and lawyers who are members of the American Law Institute, in their restatement of U.S. foreign relations law, said that the president has general power to terminate treaties. But they left open the possibility, and I think it's an important possibility, that different areas might be treated differently. By different areas, I mean different subject matters. And as I said earlier, in the area of commerce, under the Commerce Clause, the president has minimal power, no power to regulate. And so the question is, where the president has this general executive authority, can it overwhelm the exclusive authority of Congress to regulate commerce? And I think the clear answer to that is no. The clear answer is that the commerce authority is exclusively vested in Congress, and it would be an act of regulation by the president of commerce to terminate NAFTA. And by that, for that reason, that act would be unconstitutional. And so what are the implications of that? The president has executive power. Commerce is constitutionally committed to Congress. The ability to make trade treaties is committed to Congress. Of course, the president has to negotiate and sign them, so it's a joint activity to make them. And I submit to you that the termination is also a joint activity. Congress would have to authorize it, and then the president would be the person who sends the notice of termination and takes whatever other action is required under Article 2205 of NAFTA. So, if the president were to act unilaterally, it would be possible for industries that are hurt, perhaps for senators or members of the House of Representatives to bring a lawsuit. They might seek an injunction. One question about the operation of Article 2205 is whether the simple giving of the initial notice would be sufficient to cause the termination, or whether an additional act is required. And that's a practical problem, because if the president sends the notice, it might be that it's an automatic withdrawal after that. Another interpretation of Article 2205 is that the president would have to take another action after the expiration of 6 months in order to perfect the termination of United States participation in NAFTA. So I think this is justiciable. It's something that could be the basis for a lawsuit. That was something we learned in the 2013 decision in that same case of Zivotofsky, where the U.S. Supreme Court limited the political question basis for avoiding adjudication. And so I think it could be adjudicated. Whether it could be adjudicated in a timely way to prevent termination is another question. Thank you.
Thank you, Professor Trachtman. It's been really very stimulating discussion, and obviously for us here in Mexico, it's extremely important to try to understand what is the process of eventually implementing Article 2205 of the NAFTA, and I will just read from the NAFTA text what it says. Article 2205 is the withdrawal clause or exit clause. It says a party may withdraw from this agreement 6 months after it provides written notice of withdrawal to the other parties. If a party withdraws, the agreement shall remain in force for the remaining parties. So I guess that one of the reasons why we're sitting right here discussing this issue right now is because President Trump has said in a number of times that he's not happy with the NAFTA, and he even intended to sending a letter on April 26 to Mexico and Canada saying that the U.S. was not going to be part of this based on Article 2205. We know that this is a campaign promise, and we know that, as you mentioned at the beginning of your talk, that he is talking to a base that wants to hear easy solutions that basically are targeting issues that have to do with domestic problems related to inequality and jobs in the US, and obviously respond to a base that has been left behind or that is not perceiving the benefits of globalization. As you mentioned, Professor Trachtman, I think that one of the main questions for us, and I think that the fact that this is something unprecedented, we have not been able to explore in the past, makes it even more difficult for us to try to really figure out where we're standing. And this level of uncertainty and this level of lack of evidence or experience with respect to this proposal from the US is, it's creating a lot of uneasiness, at least in Mexico. We know that Canada has this safeguard with the Canada-US Free Trade Agreement, but we don't. And from your discussions, I wanted to bring a couple of issues to the discussion. Mexico has had in the past experience with other trading partners where they have denounced our respective free trade agreements. Let me offer you a couple of examples that we have experienced in the past. The first one was Venezuela. In 2006, I was part of the Mexican government. I was working with the Ministry of Economy. And the Minister of Foreign Affairs in Venezuela sent a diplomatic note to the Ministry of Foreign Affairs in Mexico, Secretaría de Relaciones Exteriores, and that letter, they basically used the exit clause. So the Ministry of Foreign Affairs sent a notification to the Ministry of Economy that landed on my desk, and that said that Venezuela had use the trigger clause in order to be able to withdraw from the G3 agreement between Colombia, Venezuela, and Mexico. And that was not nice. It was not nice to receive that kind of notification. But in Mexico, the Ministry of Foreign Affairs just took note of that diplomatic note. It interpreted literally what that said. And obviously, there was probably not much we can do because, as you mentioned, also in part of your talk, there's a great deal of cooperation in these agreements and reciprocity. We need to feel that we have a win-win situation and that we want to be in these international agreements, otherwise we would not be there. But Venezuela did send that note, and Venezuela did withdraw from the agreement within the 6-month period, and obviously our trade collapsed. Our exports to Venezuela fell down dramatically, and also our investments were in jeopardy. There was a case of the Mexican cement company, Cemex, that was basically expropriated by the Venezuelan government, and it suffered a lot. No? The other example that we have is also from Bolivia. Bolivia also denounced the agreement, but was willing to negotiate something smaller, a smaller ambition. That basically meant going from a comprehensive free trade agreement with rules and disciplines for trading goods, services, and also investment, intellectual property rights, and dispute settlement mechanisms, to a very, very small agreement that has to do with free trade in goods and some disciplines. So we have those experiences, and from both experiences, we have seen how much Mexico loses in terms of trade, investment, but also in terms of its own trade policy agenda that has been trade policy that is based on building a network of free trade agreements. Mexico today has 12 free trade agreements with 46 countries, obviously the US being our most important trading partner, and the NAFTA being our first comprehensive free trade agreement in the world. So we do have some bad experience to show in terms of those agreements taking place, those instances taking place in which the trigger clause is activated. I'm not saying that we are equating the US and the US constitutional structure, that you have very clearly explained to us. I'm just saying that it does open a whole host of questions on what's next. And I guess that one of the questions that I wanted to ask you with respect to the possibility of President Trump terminating NAFTA and triggering the withdrawal Article 2205 would have to do with the mechanics of how do you think this would take place. You mentioned that the president does not have statutory authority, but may have executive power. So that would be something that I don't know if you could elaborate a little bit more on how do you see those the mechanics in the U.S. executive branch taking place. Another question that I would like to ask from you is if you could elaborate a little bit more on the worst case scenario. Let's say that tomorrow President Trump decides that either he does not like the renegotiation that the three countries did, and so he doesn't like the package, or simply he just wakes up one morning and he says that he is fed up with this process and he doesn't want the NAFTA anymore. How do you see a process of challenging that decision in the court? Who do you think would be starting? Who could start this challenge, or who could take the president's decision to a court consideration? Who would do that? How long would that take? I remember, and I don't know if this is a valid comparison, what happened with the veto, the migratory veto that he wanted to implement the first days of his administration. It was taken to the court, and the court initially rejected it, and then there were some other movements that needed to be done in order for President Trump to actually had his migratory veto to some nationalities. So I don't know if that's something that we could use as a reference of what to expect, or if that's something completely different, given that immigration policy is a different realm, or cannot be compared with respect to commerce. And also, I think that what you're mentioning also with respect to the executive authority to impose tariffs, I think that is also another question that we would love to hear a little bit more from you in terms of how do you think that could take place. Right now, the reciprocity that we have between Mexico and the US, and obviously extending to Canada, with a few exceptions in the Canadian case, the reciprocity goes from not applying tariffs, I mean, basically we have no tariffs, to the rules. I mean, we have agreed to have a set of rules that we apply on a very predictable way. We have dispute settlement mechanisms that we may not love, but they're there, and they help to have a smooth trading relationship. However, if we are going to translate that reciprocity to the result of the agreement, meaning the US has a trade deficit, Mexico has a trade surplus, or according to Bob Lighthizer, the US has lost 700,000 jobs in the manufacturing sector, but according to some other information, we know that there are 14 million jobs in the US that depend on trade with Mexico and Canada. So where is that definition of reciprocity? Is it the reciprocity that we have in the rules and disciplines in the NAFTA, and in terms of the tariffs that we apply to each other, which are basically zero, or is that reciprocity translated into the results of the agreement? I don't know how you would explore that, or how the executive could use those numbers in order to make the case that the U.S. is not getting a fair treatment, as President Trump has posed in his political speech, his campaign, and the way he addresses his base, his political base. So I would like to hear more from you, so I will stop here, and I appreciate very much your comments on these issues. Thank you.
Thank you for those very incisive and important comments. By way of responding, I want to first say that the United States, as you know well, has many different constituencies and interests. And we have lots of exporters as well as importers that value the relationship with Mexico greatly. So, for example, our agricultural interests, our auto manufacturers, all of supply chain integration in North America, which has been the basis for lots of investment, has caused many political forces, both governmental forces and private forces, to support NAFTA. And so I think it's important to recognize that, that there are a lot of people with power, and it may be that that would cause Congress to refuse to accept termination. It's possible. It's constitutionally possible that Congress could pass a statute today saying the president has no power and shall not send a notice of termination. Of course, for that to be a statute, the president would have to sign it, or we'd have to be able to override the veto. So it's unlikely that we would see that statute today. There's also, I think, a recognition that the United States has compromised its leadership position in the world generally, but especially in the world of trade, by withdrawing from the Trans-Pacific Partnership. Actually, one thing I wanted to point out, and it is relevant to our discussion, is that withdrawal from the Trans-Pacific Partnership is the only real action that has been taken by this president with consequences in the world so far. So threats to impose national security-based restrictions on imports of steel and aluminum, threats to take action against China in respect of currency manipulation, all kinds of, as you mentioned, campaign-based threats have come to nothing because this president has confronted reality in the form of politics, in the form, to some extent, of good sense, and has backed away from those threats. And you saw 10 days ago that this president threatened to immediately withdraw the United States from the KoreaUS Free Trade Agreement, and the Republican and Democratic leaders of our Senate, of our House Foreign Affairs, of our House Ways and Means Committee and our Senate Finance Committee sent a letter saying, don't do that. That would be precipitous and dangerous. So I think there's a sense in which this president is more threat than reality. I know that's cold comfort because, as you say, it's quite dangerous to both of our economies and our peoples if this were to come to fruition. So you asked, what are the mechanics in the executive branch? If the president were to decide to act unilaterally, it would be a simple matter of either the president or the United States Trade Representative sending a diplomatic note asserting that the United States is exercising the authority under Article 2205 to send that 6 months notice. I'm glad that you read the language of Article 2205 because it says you may withdraw after 6 months notice. And so that's the question I was referring to. What does it mean to withdraw after 6 months notice? Does it happen automatically, or maybe the better interpretation is the opposite? And you asked about the worst case scenario. So the worst case scenario is the president sends that notice and it's effective and we withdraw, and then United States tariffs would revert to their WTO level. The United States and Mexico are both members of the World Trade Organization. And the average United States tariff is about 3.5%, which obviously there are different tariffs on different products, so that would be significant for some businesses, not so significant for other businesses. And all the other cooperation would end, and that would be the worst case scenario. As you know, Mexico's tariffs are higher, and so in a sense, it would be, in that narrow sense, it would be worse for the United States than it is for Mexico. But it would be a bad outcome for everyone. And by the way, it would reduce the competitiveness of North America, reduce the competitiveness of the United States in manufacturing. And I think from the United States perspective, for a moment, it would mean that I assume Mexico and Canada would turn more to the European Union, with which each of Mexico and Canada have free trade agreements, and would turn more to Asia and other partners, and the United States would become more isolated. And those jobs and that inequality wouldn't change very much at all, but the one thing that would definitely change is, well, the two things that would change are United States competitiveness and the overall welfare of the American people, because goods would become more expensive for us and it would be tougher for us to compete in world markets. So I think it's a worst case scenario for the United States as well as for Mexico and Canada. I do want to say, and you expressed skepticism, which I share, about the 700,000 jobs lost due to NAFTA. I think it's very hard to get an empirical fix, but most economists who have looked at this, the consensus among economists is that in the United States, NAFTA has had almost no effect on jobs, and except in connection with the lowest skilled workers in the United States, no effect on wages. So it hasn't been something that has delivered a lot of jobs, but it's delivered a lot of welfare in terms of consumption opportunities, and we don't know the counterfactual. It may be that without NAFTA, the United States would have become less competitive, and there would have been fewer jobs. So then this question of who would be in a position to sue. Really, industries that are harmed would be in a position to sue. So I would expect the U.S. auto industry, the electronics industry, maybe some organization of American industries to bring a lawsuit. Members of Congress could sue also, I think. And they would seek, as you suggested, it would be comparable to the early immigration bans on people from Muslim countries that the president sought to impose. And courts could provide a quick preliminary injunction on a showing that there would be damage that couldn't be addressed through later remedies. So it's possible that there would be a preliminary injunction. The question I raised earlier is, what would that be an injunction against? Would it be an injunction against sending the subsequent notice after the 6 months notice? So that's just a mechanical question that I don't have a clear answer to. I don't think the treaty language is clear enough on that issue. It's also possible that Congress could legislate, or a court could order the president not to send that notice of termination, or not to send the subsequent notice, and the president could ignore either of those mandates. And that would put the United States in a constitutional crisis. So the title of this discussion that COMEXI prepared is a correct title. It's a question for the United States, which we haven't faced recently before, of whether our constitutional structure can hold against possible abuse. Lastly, you asked about the authority to impose tariffs. Well, one thing that I think we have learned in the United States is that our because of the Commerce Clause limiting the power of the president, we have a number of statutes that give different kinds of authority to the president. And those statutes were written with the idea in mind that the president would be in favor of free trade. In our recent experience, presidents are in favor of free trade and Congress is more protectionist. And so the statutes are written with that assumption. And so the statutes do give broad authority, and the one I mentioned in the NAFTA Implementation Act could be a basis for the president to assert that there's an imbalance. Even today, before anything happens, he could say, there's an imbalance. Mexico provides some tax benefits for exports that we don't provide. There's an imbalance. And I'm going to impose an additional tariff on that basis. And our courts have been very reluctant to criticize those kinds of factual determinations by the president within his statutory authority. So I think the president could take advantage of that lack of discipline and come up with something that, in his opinion, is a lack of reciprocity. So the definition is a soft one in favor of this president.
Well, thank you, Professor Trachtman, for this very insightful discussion. I mean, definitely this is something that we hope we don't end up in a constitutional crisis in the US, because that would affect Mexico, of course. So I think that right now we can go to the questions from some of the people who are participating in this webinar. I'm going to read the question from Genaro Alarcón. He wants to know if the executive authority, does the executive authority to modify tariffs would also include rules of origin?
The rules of origin are, as you know, specified in the NAFTA treaty itself. I think that the authority that I mentioned and the other authorities that exist under our statutes are simply about the specification of the tariff itself, not about the rules of origin. So I think, I'd have to actually go back and double check, but I think that the president would not have unilateral authority to change the rules of origin. I know that that's one of the things that the United States has suggested changing, including on autos, adding a higher threshold of North American value added, and perhaps adding a requirement for 35% or some percentage of United States value added. I think that would be discriminatory against Mexico and Canada, and may raise significant issues under the World Trade Organization legal authority for free trade agreements. But to answer the question, I don't think that the president can unilaterally change the rules of origin.
Thank you. Mariana Campero poses the following question. Today's Republicans are not necessarily pro-trade as opposed to those in 1994. It might be the case that if Trump triggers the exit clause, very few Republicans will be willing to take this issue, especially during the midterm elections. Can this issue linger in Congress, or will they be forced to act?
It's a very good question. You know, I think Trump is a new kind of Republican, and in some ways he's his own person. And as Mariana suggests, traditionally the Republican Party has been more the party of free trade, while the Democratic Party has been more concerned about workers' rights and less willing to accept free trade. I think that dichotomy is finished, and probably there are free traders, still probably a majority of Republicans, at least in the Senate, maybe in the House as well, are in favor of free trade, and probably also a good number of Democrats. As you may know, Senator Schumer, the leader of the Democrats in the Senate, and the other Senate Democrats have recently issued a new document called A Better Deal, which is the Democratic view on trade, and it's populist also, and it tries to compete, I think, in populism with the Trump approach. And so there's a serious question whether the Democrats would join with anti-trade Republicans or some portion of the Democrats. I'm comforted by the fact that in our Congress, we still have a lot of very practical people who are willing to look at reason. And as I said, in connection with the Korea-US Free Trade Agreement, the heads of both parties in the Senate Finance and House Ways and Means Committee said, we need to be careful about breaking these relationships. So I think it's a good question, and we don't know yet how things will turn out. I would personally be surprised if you could pass a statute authorizing withdrawal from NAFTA at this moment, but it's not impossible.
Thank you. Renato Marignoni from Fletcher, he asks, Professor Trachtman, when NAFTA was ratified, it became part of the supreme law of the land of the United States. As such, would the withdrawal from NAFTA require further measures to remove those obligations from the U.S. legal system, or does the termination of the agreement automatically affect U.S. domestic obligations?
Yes, it's an important point, and the NAFTA implementation statute, as the questioner suggests, made a number of changes in internal United States law. The termination of NAFTA would not have the effect of terminating the statute, of repealing the statute, and so it would be a zombie statute that would persist. As I said, it could be that the president could then declare different tariffs and do some other things, but the statute would persist. And I think it would require, for good order, to have consistency in our policy, Congress to repeal NAFTA. But Congress might rebel and say, we're not going to repeal the statute, even if the president has purported to terminate the treaty, and the statute could persist with the obligations that it has. I would say that for many of the more recent American free trade agreements, like the Korea-US Free Trade Agreement, the statute specifically states that if the treaty terminates, the statute will terminate automatically. That raises interesting constitutional issues, because it seems to, if the president were to have the power to terminate the treaty, it would seem to delegate the internal power to repeal a statute to the president, which I think would be unconstitutional. So it raises some questions, and to me it raises an important question about whether Congress might have intended to give the president authority to terminate, and the answer would be no, because it would be unconstitutional for the president to terminate the treaty with the effect of terminating the statute. But it's an important question, and these statutes have not been written perfectly clearly about the authority to terminate the treaty. And in the NAFTA implementation statute, we don't have clarity about what happens to the statute if the treaty were to be terminated.
Thank you. We have also a question from Beatriz Leisevi. She asks, there has been an important number of scholars and trade lawyers that hold another position with regard to the president's power to withdraw from NAFTA. Do you have any comments on their arguments or the main arguments?
Yes. So as I mentioned, the American Law Institute, which is an august body of lawyers, scholars, and judges, in its 1987 Restatement of Foreign Relations Law, said that the president has the authority unilaterally to terminate treaties, including executive agreements like the NAFTA. but it made that as a blanket statement, and it made it based on practice. So in our constitutional system, we have the idea and the approach that there might be some interpretative value of actual practice between the Congress and the executive. And so the scholars who have made this argument have said, well, since the beginning of the 20th century, really since the 1930s, there have been some instances in which a president has terminated on behalf of the United States some treaties without congressional authorization. I looked carefully at recent history in the commercial area, and in the vast majority of cases of commercial treaties, so I'm thinking about the Commerce Clause, in the vast majority of cases of commercial treaties, there has been statutory authorization for termination. In only a couple of instances can we say that the president seems to have acted without some statutory or other congressional authorization. So then the question is, are those exceptional cases enough to establish sufficient practice to cause us to interpret the Constitution, because it supports interpretation, as giving the president this executive authority to terminate treaties? And I think when we've spoken in our Supreme Court about the use of this constitutional practice, this historical practice, we call it gloss, we've talked about it being consistent. And I think it clearly has not been consistent enough. And as I said, it might be consistent enough in other areas where the president has greater power. But in the area of commerce, which includes trade treaties, given that Congress has exclusive authority, and the Supreme Court has specified that, I think it would be unusual to say that that exclusive congressional authority is overcome by a couple of exceptional instances of presidential action without congressional authority. So it's a good question, and my view is definitely a minority view, but I think there are strong reasons to question the conventional wisdom in this context.
Certainly, we are exploring new areas that we never thought that we were going to be exploring. If I may, I just want to make a quick question to you that it's probably more related to politics rather than the legal aspect of this. You mentioned when you were replying some of the comments that I made, that with respect to the Korea-US Free Trade Agreement, some leaders in Congress sent a letter saying, questioning the executive's intention to withdraw from that Korea-US Free Trade Agreement. We didn't see that in NAFTA. Does that have to do with nuclear weapons in North Korea or the missiles in... I mean, I was kind of surprised and a little bit disappointed that we didn't have that kind of defense on the congressional side. What's your view on this?
Well, you're correct, of course, that one of the reasons for not withdrawing is to support our ally, South Korea, in a very frightening security crisis. So that's definitely correct. I also think that the president's threat to withdraw the United States from the Korea-US Free Trade Agreement was much more immediate than his threat to withdraw from NAFTA. You may recall, in connection with an earlier threat, President Trump had conversations with the leaders of Mexico and Canada, and he decided, really as a personal matter apparently, to desist from that threat. So I think under those circumstances, perhaps Congress, those people in Congress said, I need not act formally at this moment. I'm sure that many in Congress have raised this informally as a concern. So I think you're right, these are slightly different contexts. I think if withdrawal from NAFTA became imminent, I would expect to see the same letter come to the President from those same people as well as from other people, because as you mentioned in your remarks at the beginning, the trade relationship bilaterally between the United States and Mexico is our most important trade relationship besides the Canadian relationship, and there are many in Congress from agricultural states, from states that have important businesses that engage in trade with Mexico, who would object and would say this can't happen. So it's interesting that it came up in that case, but I think it was based on specific facts.
Okay, thank you. And we just have one last question from Beatriz Leitegui. She was asking if you could offer some literature that addresses those cases in which the President has withdrawn from trade agreements with statutory authorization or vote and without congressional authorization. Is there any literature that you could direct us to?
Yes, I have a paper on this topic that recounts my review of the history, the recent history in this area, and refers to the other literature on the President's power to withdraw from trade agreements. That paper has been posted on the Social Science Research Network. So if she were to Google my name at the Social Science Research Network, she would find that paper. Otherwise, if it's more difficult, send me an email and I can point her to it.
Thank you very much. Well, I think that this is the end. Thank you, Professor Trachtman. My pleasure and my honor to be here with you today.
Thank you. It's been my pleasure and honor.
Thank you very, very much, Professor Luzma. It really has been an interesting conversation, and I will make sure, Professor, that all the participants receive your paper. I will email it to everybody. Thank you very much. A pleasure. Thank you.
Thank you, Mariana. Thank you, COMEXI. Thank you.